Myself, Suganya VS. I completed MCOM MPhil. I am working as a assistant professor in Department of Commerce at St. Josephs College of Arts and Science for Women. Here I am going to talk about 2 Industrial Dispute Act 1947. Authorities under Industrial Disputes Act 1947. Work Committee Section 3. Conciliation Officers Section 4. Board of Conciliation Section 5. Court of Inquiry Section 6. Labor Court Section 7. Industrial Tribunal Section 7A. National Tribunal Section 7B. Work Committee Section 3. Constituted based on appropriate government order applicable to industrial establishment in which 100 or more workmen are employed in any day in the preceding 12 months, consist of representative of employees and workmen engaged in the establishment. Number of workmen representative shall not be less than the number of employers representatives. Conciliation Officers Section 4. The appropriate government by notification in the official gazette appoints a specific number of persons as it think fit to be as conciliation by officers. Conciliation officer may be appointed for a specified area or for specified industries in specified area either as permanent or for a limited period. A conciliation officer shall be deemed to be as public servant as per section 21 of Indian Penal Code 1860. Duties. When any industrial disputes exceed the conciliation by should hold conciliation proceeding in prescribed manner without delay to have right settlement. Whether settlement is reached or not, the conciliation of must submit the report within 14 days of commencement of the conciliation proceedings or within the date fixed by appropriate government. If the report submitted is satisfied to the appropriate government, it may or not refer to dispute to any authority under the Act. If the government is not making any reference, it should record and communicate the reason to the contending parties. The duties of conciliation officer is administrative and not justicial. Board of Conciliation Section 5. The appropriate government by notification in the special gazette constitutes a board of conciliations for promoting the settlement of an industrial disputes. The board of consists of chairman and 2 or more 4 other members as the appropriate government think fit. The chairman shall be an independent person unconnected with the dispute. The other members shall be person appointed in equal number to represent the parties to dispute. The person appointed to represent a party shall be appointed on the recommendation of the party. The appropriate government appoints a fit person as it thinks. If any parties fail to make recommendation within a prescribed period, a board of conciliation can act only a dispute referred to it by the government. Court of Inquiry Section 6. The appropriate government by notification in the special gestee constitutes a court of inquiry into any matter relevant to an industrial dispute. A court of inquiry consists of one independent person or of number of independent person as the appropriate government may think fit. Court of inquiry consists of two or more members. One of them shall be appointed as chairman. The court of inquiry can act under the prescribed quorum even at the absence of chairman. If the service of the chairman is seized by the government through the notification, the court shall not act until a new chairman has been appointed. All the members of a court shall be deemed to be public servants under section 21 of the Indian Penal Code 1860. Every inquiry by a court shall be deemed to be justicial proceeding. A court of inquiry has same powers as a civil court under the Code of Civil Procedure 1908. The court has the right appointed one or more person having special knowledge of the matter of the disputes as an advisor. Duties. A court shall inquiry into the matters referred to it and report to the appropriate government within a period of 6 months from the commencement of inquiry. The report of the court shall be in writing and signed by all the members of court. Members are free to record their dissent. The report submitted shall be published within a period of 30 days of its receipt by the government. Labor Court. Section 7. A labor court consists of one person only to be appointed by appropriate government. A person shall not be qualified for appointment as presiding officer of a labor court unless he has been a judge of a high court. He has been as a district judge or additional district judge for a period not less than 3 years. He has held any judicial officer in India for not less than 7 years. Industrial Tribunal. Section 7A. The appropriate government by notification in the official gazette constitute one or more industrial tribunal for the adjudication of industrial disputes relating to any matter specified in second or third schedule. The tribunal consists of one person to be appointed by the appropriate government. A person shall not be qualified for appointment as the presiding officer of an industrial tribunal unless he has been a judge of high court, he has been a district judge or additional district judge for a period of the 3 years. National Tribunal. Section 7B. The central government by notification in the official gazette constitute one or more national industrial tribunals for the adjudication of industrial disputes involving question of national importance, which are of such a nature that industries are more than one state are likely to be interested in or affected by such disputes. Matters appearing in second and third schedule. A national tribunal consists of one person to be appointed by central government. A person shall not be qualified for appointment as a presiding officer of a national tribunal unless he is or has been a judge of high court. Thank you.